Judge Reid, I want to ask you some questions as we near the end of our session, and one of the questions I want to ask you is about how do you define what a good judge is?
Oh my gosh. Well, there are several characteristics. I think the first, it may sound a little odd, but would be a dedication to the concept of law, the rule of law. One of the most distressing things that I have ever heard a judge say was, election time is coming and the penalties are going to get stiffer. Others say, I don't care what the law is, what I'm doing is right. We all have different views of what is right, and a judge is the arbiter, and the judge ought to respect the law. We were having interviews for Attorney General one time, and I confessed to some mischievousness. I asked this one judge, this one applicant, and I sort of knew his history. I said, well, suppose you had a situation in which the law clearly required you to do this, but in your heart you knew that it ought to go the other way. Which would you do? Oh, well, I'd do what's right. Well, he didn't have a chance of getting my vote because he was substituting his ideas for justice over what is we all have agreed as a society, as a people, that we must respect the law. And so I think respect for the law, obviously impartiality, integrity, doesn't have to be real smart, really. That's to work hard, but it doesn't have to be real smart, just reasonably smart. I would rather have a judge with limited smarts anytime if he'll be fair, give me a chance to argue my case, and make a decision based on what he understands the law to be. So I think those are some of the qualities that I think are important.
During your term on the Supreme Court, Tennessee adopted comparative fault. It's modified comparative fault in Tennessee. And there's been some conversation that was a type of judicial activism. What are your comments on that?
Well, my first comment is that the judiciary is the third equal branch of government, and just as important, in some instances more important, than the other two. For instance, I never would have agreed, had I been on the court, for the legislature to pass on court rules. That was an accomplished fact when I got there. It did not seem to me it was the right thing to do, and were it before me, I would have said, no way will I give up the prerogative of the judiciary with regard to our court proceedings.
We're talking about comparative fault. Was that
comparative fault was a good example, but not the common law. There is not a rule for everything. The legislature has never thought of everything, and even if it had, it wouldn't fit all circumstances. So the court plays a role in law development, and that particular issue, comparative fault, negligence, in the beginning was a creature of the courts. Before the Parliament did not pass a law making negligence actionable or a cause of action. A court in England said that this particular incident, and I think I remember my law school, it was the defendant in that case had strung a wire across a public street, and a horseman had been decapitated or seriously injured from riding under it. The court said that's negligence, and there is an action on the case, I believe it was, in that case. And from that time on down, the development of negligent law has been a development of the common law. So comparative fault is nothing more than a development of the common law, and a very reasonable one in my view.
I want to ask you about the area of criminal justice. What is your view of where we are as a society and as a state with our criminal justice system?
Well, we don't do criminal justice very well. Whatever we say we're doing, we are punishing, and in my view, very little effort is made towards rehabilitation or saving the offender, saving them for some useful purpose. It's terribly expensive. It's expensive in the money that we hand out in the form of taxes spent for prisons, and it is terribly expensive in the way of human personality, because these people who get caught up in the system, it is most difficult to get out of the system. I have said somewhat irresponsibly, I think, that a deputy sheriff had more to do with the criminal justice system than I did as Chief Justice of the Supreme Court, because it's the deputy sheriffs that put you in the system. And once in, it doesn't deal with people very well. So many young men, particularly young African American men, are going to prison, and without any real hope of ever surviving in any sort of responsible citizen, or even as a citizen who has a chance of participating in or having the things that some of us almost take for granted. There is a concept that favors rehabilitation over punishment that really, I think, comes nearer solving the problem on behalf of the victim, the state, as well as the offender. As a matter of fact, one of the things that I did recently, I met with the staff of, they asked me to come over and talk about it, the staff of the Wilder Training School at Somerville, which houses juvenile offenders. They're trying to start a restorative justice concept.
Now, I've heard you speak of restorative justice a lot. What does that mean?
Well, nobody knows what it means, really, at least I don't. It means a different way of looking at crime and punishment, a way that hopefully serves the interests of the victim. In the last few years, the legislature has passed what they call victims' rights. There's not really much substantive rights there, in the sense that the people who have been hurt their hurt is redressed in any sort of meaningful way. Almost the total emphasis on punishing the offender, and that's fine. I mean, if you do something wrong, you can expect things to not ever be quite the same, but there ought to be a system in which there is hopes of reconciliation. I suppose that my understanding of restorative justice is more of a reconciliation. There have been some good results. It doesn't fit. There are some people who are so bad and who are so violent and who are so totally destructive that they have to be locked up. But all the people who are locked up don't fit that category. And if you want to get into the causes and the mechanics of doing it, I think that our focus on drugs plays an important part in there. Restorative justice is a great concept in the sense that it hopes to do better for the victim as well as for the offender, and in no small way better for society generally.
And have you been giving seminars and lectures on that over the last few years?
Well, no, not lectures. I try to stay away from lectures. The the women of the Methodist Church asked me to do a program, and I did it over a couple of day period, and then they had to have a program in their church, so they said, oh well, maybe Judge Reid will come to our program. So I've done the same sort of thing. I'm encouraged by the efforts that are being made by the staff at the Wilder Youth Center as to what some good might come of that. These are high school children. These are children who have never known, some of them have never known how to deal with conflict except first to yell, then to hit, and then to hit with a stick, and then to shoot. That's their experience with conflict management. And it's terrible, and we must be able to to provide a better system than that.
Well, you have had a lot of experience. You've, as a lawyer and a judge, what's the difference now that you're back being a lawyer again? You walk in the courtroom, and here's the former Chief Justice of Tennessee Supreme Court, and he's in here to argue a motion or an appeal. What's the difference?
Well, I used to tell my colleagues on the court that I was a lawyer so long that I never would be a proper judge, and actually most of them agreed with me at the moment. But it is different. I do enjoy being a judge. My success, I mean, as a lawyer, I enjoy being a lawyer. My success as a lawyer has not been outstanding, and I wonder why you've kept me on. I've tried two cases in the Supreme Court and was a colossal failure on both of them. One of them was a negligence case, and I thought we had a slam dunk winner. We ended up losing 3-2, and in the process have been told that even in a common law action, doctors have no duty to third parties, which is the way I read the opinion, and it's kind of startling. I'm sure that's not what the court meant, and I'm sure they'll get around to dealing with that. So that wasn't so good. And then in a more recent endeavor, maybe tying up all the loose ends so far as I'm concerned on the Tennessee plan and how to select judges, even after it was apparent that you would not be a member of the Supreme Court, at least not on this go-around, because of the situation that had developed. With your permission, we continued in the case in an effort to, if you will, protect the plan, which I had a lot to do with its beginning, and I think it's a good plan, and we both wanted it to be preserved. The Supreme Court again did not see fit to adopt our argument, which I thought was terribly simple and terribly right, but they didn't. So I can tell you one thing, that no deference is given former Chief Justices, and they smiled and say, nice to have you, let's hear your argument. Haven't been in the trial courts much. They have, everybody's always nice, and everybody's very, very respectful, but they don't give you any quarter, and they shouldn't, absolutely not. I can tell you that making an argument before the Supreme Court is, I think in the last case that we had a loser, as it turned out, but I think that's the most fun 10 minutes I've had in a long time.
That's great. Let me ask you this. I've got two questions I want to ask you. One of them is a question I ask. In fact, they have it on the break room in our office, the question I ask. But the one I want to ask before that, what kind of people do you admire?
I admire, that when you get as old as I am, and you start to wonder, what could I have done? Here I've spent my life in Tennessee and had as many failures as I've had successes, and though I have enjoyed it, maybe if I had done things differently, I could have had more impact. I could have done things better. I think greatness and better and whatever can only make sense in the context of the moment. And the people that I admire the most are those who do what's before them well. And that's a lawyer, it's a chef, it's whatever it is, wherever you are in life. Don't worry too much about tomorrow. Don't worry too much about what people are going to say about you. Face up to what task you have taken and just look at it and try to do it. If it's writing a letter right now in our practice, if it's writing a letter to opposing counsel, sit down and write the very best letter that you can. Everything we do as a lawyer is we're an advocate. The simplest letter is advocacy. And if you're writing a letter, if you're writing a brief, if whatever, do it well and everything will be okay.
And the last question is, are we having fun yet?
We're having fun. I have to tell you that the practice of law and my experience on the court, and I think over the years I have experienced what I set out to find out about, how people are at their best and at their worst, and how are we, when it comes down to, I think, is the most fundamental thing among people that can be, and that is justice. Do we treat each other right? Why don't we? When don't we? What is justice and what is not in our civil relationship, in our family relationship, political, and that's what I think is the most important thing.
And now, is there anything that you want to say before we end this?
Well, yes, there is. I want to say thank you to Barry and the sponsors of this project, the Bar Foundation and the Historical Society. I want to thank you. I'm not altogether sure it's a good idea, but since you are doing it, I am pleased that you invited me to participate. And I want to thank you, Houston, for leading me through. I'm glad it was direct rather than cross-examination.